In the autumn of 1921, a land surveyor named Clarence Moswell walked into the regional office of the United States General Land Office in Washington, D.C., carrying a leather satchel, a folded deed from 1887, and a notarized letter signed by 3 sitting county judges. He had traveled 11 days by rail from Knoxville, Tennessee. He had spent 9 years gathering the documents in that satchel. He wore the same gray suit he had worn to his daughter's wedding. By the time he left that building, his deed had been stamped invalid. His notarized letter had been filed in a drawer and never retrieved, and the clerk who processed his case had written a single word across the top of his intake form, inadmissible. Clarence Moswell went home. He died 14 months later. His daughter said he never once stopped talking about what that clerk had told him across the desk that afternoon. The first thing the clerk said was that Clarence's family had never legally owned the land they had farmed for 34 years. The second thing he said was that no law existed, nor had any ever existed, that would allow them to own it. The official record of that visit does not exist. The intake form has never been located. The General Land Office's files for that regional desk, covering the years 1919 through 1924, are listed in the National Archives as damaged beyond recovery. The water main that flooded that section of the archive broke in 1931. It flooded no other section. Clarence Moswell was not delusional. He was not an agitator. He was a licensed land surveyor who had spent 31 years measuring property boundaries for the state of Tennessee, a man whose professional certifications were issued by the same federal government that had just invalidated his family's claim. He had no history of legal disputes. He had never missed a tax payment. The land his father had broken from raw forest in 1887 had been farmed continuously, taxed continuously, and passed through a legal estate proceeding in 1904. None of that mattered. None of it had ever been designed to matter. Before we go further, if you find these buried records as fascinating as I do, hit subscribe so the next one finds you when it drops. The algorithm tends to suppress this kind of research, unless you tell it otherwise. Now, back to Clarence Moswell. To understand what happened to Clarence, we have to go back, not just a few years before his trip to Washington. We have to go back to a legal architecture that was constructed over the course of nearly 6 decades, piece by piece, in ways that the history books have never once assembled into a single coherent picture. Because the laws that governed land ownership in the United States between 1862 and 1934 did not simply favor certain groups over others. They were engineered, in specific and documented ways, to make permanent land ownership structurally impossible for specific categories of Americans. And then those laws were quietly rewritten, reclassified, or allowed to expire without a single public accounting of what they had done. The Homestead Act of 1862 is the version of this history that most people were taught. Free land. 160 acres. Any citizen who could farm it for 5 years. The promise was real enough that it drew hundreds of thousands of families west and south and into the hill country. Families who cleared timber by hand, built homes from the earth they plowed, and lived and died on land they believed was theirs. What the textbooks omit is the machinery that operated beneath that act for the next 70 years. The residency requirements that were changed without public notice. The soil classification amendments that could retroactively reclassify productive land as non-arable and therefore ineligible for final patent. And the network of regional land offices staffed by political appointees who had enormous discretionary authority to approve or deny final deeds with no appeal process that a working farmer could realistically navigate. Most of these farmers were not near a courthouse. Most of them had never spoken to a lawyer. Most of them had no idea that the deed they had been farming toward was not, under the administrative rules being quietly rewritten in Washington, theirs yet. A 412-page report submitted to the Senate Committee on Public Lands in 1908. A document with photographic plates, original survey maps, and sworn testimony from 61 witnesses in 14 states. Documented 23,000 cases in which settlers who had met every legal requirement under the Homestead Act had been denied final patent. These were people who had cleared the land, farmed it, paid taxes on it for 5 years or more, and been told they did not own it. The report was commissioned by Senator Robert M. La Follette of Wisconsin. It was received, acknowledged in the Congressional Record on March 4, 1909, and assigned to subcommittee. It was never brought to a floor vote. When researchers attempted to locate the original document in 1967, the Senate Library reported that the file had been transferred. The transfer destination was listed as Bureau of Land Management, Western Division. The Bureau of Land Management, when contacted in 1967 and again in 1974, reported no record of receiving it. The report still exists, in part. 14 pages of it were reproduced in a 1913 progressive journal called The Public, published out of Chicago. Those pages survive in the archives of the Newberry Library in Chicago to this day. If you visit the Newberry and request the 1913 holdings of The Public, the staff will locate it within the hour. The 14 pages are there. What they contain is enough to understand what the full 412 pages documented, and enough to understand, very clearly, why those 412 pages needed to disappear. What the surviving 14 pages describe is a legal mechanism that researchers in this space have come to call the reversionary clause system. This was not a single law. It was a series of administrative amendments attached to existing land statutes between 1877 and 1912 that allowed land office officials to revert finalized land patents back to federal ownership under a set of conditions so broadly written that they could be applied to nearly any claim at nearly any time. The conditions included soil reclassification, as mentioned. They also included what the 1908 report called continuous beneficial use requirements, language that had never appeared in the original Homestead Act and had been inserted into administrative code without a congressional vote. No family that had farmed its land through a drought year, through a flood, through an illness that kept a man off his fields for a season could be certain that language would not be used against them. And it was used. Repeatedly, selectively, Bernard Whitfield was a land attorney practicing in Raleigh, North Carolina. He had argued before the federal bench in 17 cases between 1899 and 1921. He was not a political man. He was a careful one. In a letter to his professional association in 1919, Whitfield wrote that he had never, in 20 years of practice, lost a land case where his client was a corporation. He had never, in those same 20 years, won a land case where his client was a black farmer, a recently naturalized immigrant farmer, or what he called a settler of the mountain districts, meaning the isolated Appalachian communities, largely white, but economically marginal, who had homesteaded land without access to legal counsel. He did not say the system was corrupt. He said the system was structured. There is a difference, and Whitfield understood it precisely. His letter was published in the North Carolina Bar Association Journal in the spring of 1919. It generated no known response from any state official, any federal office, or any bar association leadership in any state. Bernard Whitfield died in 1923. His case files were donated to the University of North Carolina at Chapel Hill by his daughter in 1954. They are listed in the library catalog. They have never been digitized. The General Land Office itself was abolished in 1946. Its records were transferred to the newly created Bureau of Land Management. What was transferred, what was lost in that transition, and what was deliberately withheld from transfer has never been independently audited. The agency that held 70 years of land patent records for the entire continental United States was dissolved, and its files moved with no public inventory, no independent oversight, and no congressional hearing on what the transfer contained. The pattern does not stop with one region or one decade. Tuskegee, Alabama, 1904. A study by researchers at the Tuskegee Institute documented 114 separate cases in a single county in which black landowners who had purchased or homesteaded property between 1890 and 1900 had lost title through mechanisms that included tax sales conducted without the legally required public notice, deed recordings that were accepted by county clerks and then destroyed before the legal filing window closed, and direct pressure from county officials that resulted in forced sales at prices the researchers calculated at between 9 and 22% of assessed market value. The study was published in a 40-page monograph in 1904. The Tuskegee Institute's copy was destroyed in a fire in 1923. A single surviving copy was identified in 1989 in a private collection in Montgomery, Alabama, Gilliam County, Oregon, 1912. A federal investigator named Thomas Hatch filed a report documenting what he called systematic displacement of homesteaders in the eastern Oregon high desert. Land agents working on behalf of the Oregon and California Railroad successor companies had used the soil reclassification mechanism to void 340 patents in a 3-year period. These were working farms. The reclassification declared the soil unsuitable for agriculture. Hatch's report was submitted to the Department of the Interior. Within 4 months of its submission, Hatch was reassigned to a desk position in the District of Columbia. He conducted no further field investigations. His report does not appear in the Department of the Interior's action logs for 1912 or 1913. Harlan County, Kentucky, 1918. County records show that 211 families lost land claims in a single 18-month period through a combination of back tax proceedings and what the county clerk's own records describe as voluntary surrender agreements. Legal scholars who examined these records in the 1970s found that the signatures on 47 of those voluntary surrender documents did not match the signatures of the individuals named on the original patents. San Joaquin Valley, California, 1896. A German-born land attorney named Wilhelm Krauss filed an emergency injunction in the Fresno Federal District Court on behalf of 63 immigrant farming families from whom the Southern Pacific Railroad's land department had reclaimed plots using a soil classification mechanism. That, Krauss argued in his brief, had been specifically written to enable exactly this reclamation. The injunction was denied. Krauss appealed to the Ninth Circuit. The Ninth Circuit's ruling, issued in 1898, was 11 pages long and included a passage that 3 separate legal scholars who reviewed it in the 20th century described as internally contradictory. The court upheld the denial of the injunction, while simultaneously acknowledging that the soil classification standard, as applied, appeared to exceed the statutory authority of a private land company. The 63 families lost their land. Wilhelm Krauss's appeal brief, which reportedly ran to 200 pages and contained a full transcript of the soil classification regulations' legislative history, was not included in the Ninth Circuit's archived record of the case when that archive was inventoried in 1941. This is not coincidence. This is a pattern. The Bureau of Land Management has never adequately addressed what happened to those 23,000 cases documented in the 1908 La Follette Report. It has never explained why the soil reclassification amendments were inserted into administrative code without congressional approval. It has never explained why Thomas Hatch's Oregon report has no corresponding action record in the Department of the Interior's files. It has never explained why the reversionary clause mechanism which land attorneys practicing in the 1910s and 1920s identified as the dominant cause of settler land loss, appears in no standard legal history of American property law taught in any law school in this country. Why did the General Land Office classify its internal correspondence files, not its public records, but its internal correspondence, as restricted from public access until 1972, 30 years after the agency's abolition? Why do the surviving records of the 1908 La Follette report show that at least 6 of the report's 61 witnesses were subsequently audited by the Bureau of Internal Revenue within 2 years of their testimony? Why would an institution with nothing to hide transfer 400,000 cubic feet of administrative records in 1946 without producing a comprehensive transfer inventory, a procedure that was legally required under the Federal Records Act? These questions do not go away because institutions refuse to answer them. But here is what makes Clarence Moswell's story different from every other account of suppressed land law. In 1977, a historian named Nell Irvin Painter, then at the University of Pennsylvania, published a study of the Great Exodus, the mass migration of black families from the South to Kansas in 1879. Her research led her into the General Land Office's predecessor records, where she found a category of document she had not been looking for. They were called Final Certificate Denial Logs. They were ledgers maintained at the regional office level that recorded every denial of a final patent application. What Painter found and documented in an appendix to her study was that the denial logs for 7 regional offices covering the period 1880 to 1910 showed denial rates that varied by more than 400% depending on the racial composition of the applicant's county of origin. She flagged this finding as significant. She noted it merited further study. No federal agency has ever commissioned that study. The denial logs Painter examined were held at the Federal Records Center in Kansas City. In 1983, a researcher attempting to follow Painter's footnotes found that those specific ledger volumes had been reclassified as non-permanent records and destroyed pursuant to a General Records Schedule disposal authorization dated 1981. The destruction was legal. It was authorized. Someone had to authorize it. Clarence Moswell's family continued to farm the Knoxville County land after his death in 1922 because they had nowhere else to go and no resources to go anywhere. They paid their taxes every year. They maintained the property. They fixed the fences after storms. They buried 2 more generations in the small plot at the back of the property where Clarence's father had been buried in 1901. Raymond Moswell, Clarence's son, spent 18 years writing letters to the Bureau of Land Management, to the Department of the Interior, to his congressman, and to the Tennessee State Attorney General's office. The replies he received, and he received some, uniformly cited the same position. The matter of the original patent was a closed administrative question. The records pertaining to the denial were unavailable, and no mechanism existed through which the determination could be appealed. In 1947, unable to secure a bank mortgage on property without a valid federal patent, Raymond sold the land to a timber company registered in Memphis. He received a price the County Agricultural Extension Office's own records from that year show was 60% below the regional market rate. Raymond Moswell moved his family to Detroit. He worked on the line at the River Rouge plant for 22 years. The land in Knoxville County is still there. It is held today by a forestry management company registered in Delaware. If you contact the county assessor's office and ask about the chain of title before 1952, they will tell you the records are incomplete. They will be correct. They will not be able to tell you why, because the reason is in a file that was transferred in 1946 to an agency that reported receiving no such transfer, and the original intake form from a desk in Washington that was flooded in 1931. The timber has grown back. If you drove out there today and walked the tree line, you would find what surveyors from the Tennessee Historic Preservation Office identified in 1994: the stone foundation corners of a farmhouse, hand-laid limestone, measuring 28 feet by 34 feet. They are still there, exactly where Clarence Moswell's father placed them in 1887. The Preservation Office flagged the site as a potential historic resource in their 1994 survey. The designation was never finalized. The file is listed as pending. It has been pending for 32 years. The official history tells us that American land law was imperfect, but self-correct, that abuses were documented, reforms were eventually passed, and the system moved toward justice over time. What the evidence tells us is that specific mechanisms were deliberately built into that system to ensure that certain families could never hold permanent title, and that the documentation of those mechanisms was itself systematically removed from public access over the course of several decades. A 412-page Senate report. Regional denial logs. A federal investigator's field findings, an attorney's professional correspondence, an intake form. All of it gone, in ways that required authorization, required action, required someone to sign their name to a disposal order or a classification stamp or a transfer receipt that went nowhere. You were taught one version of how land ownership worked in this country. The families who lost the land were never asked to tell theirs. These stories survive because people refuse to stop asking. If this matters to you, subscribe and share it with someone who needs to hear it. History does not disappear when it is buried. It disappears when no one looks for it. Next week, I am pulling a thread that connects this land law framework directly to a set of agricultural patents filed between 1888 and 1901. Patents that were purchased by 3 connected companies, shelved, and never manufactured. The man who filed them had a land deed problem of his own. His name was Solomon Northup's grandson. The year the last patent was shelved was 1902. You will not want to miss it.